Welcome Till Death Do Us Plan, the podcast where love, life, and legal planning all come together.
We're your hosts. I'm Santos Vargas.
And I'm Patty Vargas. We're both attorneys and husband and wife.
Each week, we'll tackle the real conversations people often avoid, from estate planning and probate to prenups, postnups, and everything in between.
We're here to help you plan smarter, protect what matters, and feel more confident about your future.
Because life is unpredictable.
But your plan doesn't have to be.
Let's dive right into it. Estate planning horror stories. Patty, I'm sure in your practice you come across these all the time. People that come and meet with you, maybe they haven't done their estate planning, maybe they did their estate planning the wrong way. Can you tell us about some of the things that you often run into that lead to horror stories for the families involved?
Sure. I think one of the easiest things that comes to mind is just somebody who hasn't done planning at all. And as you know, when you haven't done any planning, your assets are going to pass by the laws of intestacy.
Okay. And why is that significant?
Well, that's really important because if you haven't done any planning, the state in which you live in is going to determine a lot of things. They're going to determine who gets your assets. They're going to determine who's in charge of your assets. And some of those things and the way in which that property passes may not be what you want.
So you threw around a term just a minute ago, intestacy. Tell us a little bit about what that means.
Sure. So each state is going to have their own statute that sets forth who will inherit your property if you don't have a will. And it depends typically on whether you are married or not, whether you have children or not. So that's sort of the first step. The second step is to determine whether or not you are in a community property state or in a state that does not have community property. But each state is going to make its own determination as to how your assets are going to pass.
Now, what's the easiest way that somebody that's out there listening and thinking about intestacy and some of the horror stories that come along with that can avoid it? How do you avoid intestacy?
Sure. The easiest thing to do is just to have even a simple will, which is really important because without a will, again, you're not going to be able to determine who receives your assets, but also who is going to be appointed as the personal representative of your estate. And that's a really important job because that personal representative is the one who's going to be responsible for gathering up all of your assets and making sure that they are distributed to the proper person. What I find is that there are two types of administration. There is a dependent administration and an independent administration. And if you have a will, you can select independent administration, which just makes things move a lot more smoothly and is a lot less expensive.
What are some of the other kind of key concepts that you want people to think about when they're trying to decide what should go into something like a will that will take them out of intestacy?
One of the things that's really important to think about is determining who is going to receive your assets, especially if you have minor children or maybe a beneficiary who's incapacitated, because those are typically individuals who are going to need a lot more planning done for them. For example, we're probably going to want to set up a trust for those children. And if you fail to have a will and you die by intestacy, the way in which those assets are going to be distributed becomes a lot more challenging.
And so tell me about some horror stories that you've come across, people that you've met with and during the course of your career that have come to you and said, Patty, I didn't have a will and this is what happened to me. Can you help me out?
Sure. Two situations come to mind. The first is the family where it is a blended family. So you have a spouse who has passed away with children from a prior marriage. When you have a community property state like Texas, what you will find is that if there are children from outside of that marriage, the community assets are going to go to the children, not to the surviving spouse. And so what that means is typically the homestead is a community property asset. Husbands and wives typically purchase homes together. So I've actually had to break the news before to a surviving spouse, a widow, to explain to her that their home that they bought together is not going to go to her. Instead, it was going to pass to her stepdaughter and two minor children, which causes an incredible amount of complexity because you have two minors owning the house. But more importantly, that surviving spouse only has their 1/2 interest in the homestead.
That must be just completely devastating, especially for somebody that's still grieving and trying to figure out what the next steps are. What would have been the easiest way for that person to avoid intestacy?
Sure. There are several ways that intestacy can be avoided. We've mentioned a will. The person could also set up a trust, which is a little bit more complicated, but something certainly they could do. And also in other states, there are different techniques, such as a transfer on death deed, that can be recorded during your lifetime, in which you name the person, typically a spouse, or maybe your adult children if you do not have a spouse, so that that asset, that home, passes outside of probate. But any of those techniques or any of those documents are an easy way to make sure that your home, one of your most valuable assets, passes to the person or persons that you want.
So here's a term that you often hear thrown around. Maybe whenever you're starting a new job, you're filling out all these forms that they're putting in front of you. Maybe you decide that you want to make a change to your insurance or set up an insurance plan to begin with, and they're putting all of these forms in front of you. And one of the terms that you often hear and you see is something called beneficiary designations. Can you explain what that means?
Sure. Beneficiary designations are extremely important. And unless you have a full understanding of what you're trying to achieve, a number of problems can arise. So let me give you this example that I've seen before. Husband and wife, they have a life insurance policy, and each one has a policy, and heaven forbid they both pass away in a common accident. So the contingent beneficiaries, they decide they're going to name the wife's mother as the primary beneficiary because they have minor children. That seems to make sense. It seems to be pretty simple, but the problem is that that death benefit, once it's paid to the mother-in-law, is going to belong to her. And although you may have complete trust in the mother-in-law, that money, she has under no obligation to make sure that those funds are used for your minor children. In addition, other things that can arise when you name a family member as the beneficiary of that life insurance policy for your children is that what if that individual loses capacity and they're no longer able to make distributions for your minor children and they find themselves under a guardianship? Or worse, if they pass away, that money belongs to them. It's not held in a trust. It's not distributed in some way that solely belongs to the children. And instead, it's going to pass pursuant to that individual's will or by intestacy. Or worst case, maybe, what if the individual that's named is taken advantage of by another individual so that that money is completely depleted? Regardless of the situations that can arise, and there are several, the solution is to have the proper estate planning documents in place and that those beneficiary designations are consistent with your overall estate plan so that horror stories such as this can be avoided.
So let's talk about beneficiary designations and life insurance, because I feel this is one of the most common areas in which listeners and viewers to our podcast are going to have seen the term beneficiary designation is in a life insurance application or life insurance forms that they're filling out. What are some of the key things that they need to think about when filling out those beneficiary designations for life insurance?
Sure. So one of the terms that you will see is primary beneficiary. And that's the individual or individuals that you can name that will receive the death benefit. That amount will be distributed to the person or persons that you've named as the primary beneficiary. But what happens if you've named one primary beneficiary, such as your spouse, and your spouse predeceases you or you die in a common accident? You are going to want to make sure that you have named some other individual, or in the case of minor children, a trustee for a trust you've created in your will, so that those assets don't pass to your estate. You want them to pass outside of probate. You want them to pass in such a way that it's reflecting your overall estate plan. So two of the most important terms that you'll see on that beneficiary designation form is who you want to name as a primary beneficiary and who you want to name as a remainder or contingent beneficiary. So it's important to understand the distinction and understand why it is and who it is that you're naming.
Let's talk about retirement accounts and beneficiary designations. This is a key area and a key scenario where people are going to come across an option, an election to make as to who the beneficiary is on those retirement accounts. Can you tell us what some of the key issues are that, in your experience, people really need to consider when filling out those beneficiary designations on their retirement accounts?
Sure. And it's important to remember that every situation is different. So it's important that you meet with your estate planning attorney so that he or she can guide you and can give you the proper instructions, proper information, and assistance so that as you're completing these forms, they're done correctly. But broadly speaking, it's typically recommended that for spouses, husbands and wives, that they name their spouse as the primary beneficiary 100%. And this is definitely one area where I know sometimes life insurance policies and retirement accounts can differ, because with a retirement account, you're going to have to put a percentage. So if you think about it, if you want to divide your retirement account between, let's say, 3 adult children, what you're going to find is 2 of the children are going to have 33%, and 1 of those children is going to have 34%. It's just the way that it works. I kind of joke sometimes with clients that I guess, after you pass away, one child will then in fact know that he or she was the favorite child because they got 1% more. But in any event, what's important to remember is that broadly speaking, it is the best for income tax purposes to name the surviving spouse as the primary beneficiary. As you go down in the document on that beneficiary designation form, you will see, again, that option to name contingent or remainder beneficiaries. And if you think about a typical family, husband and wife with 1 or more children, that is where you're going to start to name your children. And again, the percentage has to add up to 100%. What I will caution, though, is it's really important to read that beneficiary designation form, because let's say you have 2 adult children and you've named your spouse as the primary beneficiary. The spouse passes away, and so now we're down at this second level. And the question may be, is there sort of a check the box on the form such that if one of your children predeceases you, is his or her share going to go over to his or her surviving sibling 100%? Or is his or her share going to go down to any children they may have, their grandchildren? And that's typically something that's stated within the form, or if it is not, oftentimes you're able to provide supplemental instructions so that your wishes can be carried out. I find that these types of beneficiary designation forms, the ones for retirement accounts, can often be the ones that are the most complicated and the ones that potentially have the most risks associated with them.
What are some horror stories that you've come across in your career about beneficiary designations and how they interact with retirement accounts?
Sure. I think the worst situation is where the individual who works for a company and has a 401k plan just fails to complete that beneficiary designation form, or they think that they've done it. When they don't, one of 2 things is going to happen. Either that retirement plan is going to have some preset language within that policy that's going to say, if the owner fails to name an individual, then this default is to occur. Oftentimes what that might look like is if they're married, it'll go to the spouse. If they are not married, it may go to children, or if not to children, then maybe to their parents. That's a best case scenario, and it's not guaranteed, because the worst case scenario is really what I often find. And in fact, I'm dealing with a case that involves this right now, where individual passed away without a will, and she did not complete the beneficiary designation form for her 401k plan. So those benefits, her retirement benefits, passes to the estate, which means we had to go through probate, open up an estate, do an heirship determination in order to get her father appointed as the administrator. So all these additional hoops and hurdles had to be jumped so that the father could collect those benefits.
And what's the difference in time and money that would cost somebody?
Significant. I can really only speak to the process here in Texas, but it takes several additional steps. One, we have to file an application for a determination of heirship that's going to require the court to determine who the person's heirs are. With that proceeding, an attorney ad litem has to be appointed in order to investigate and research and confirm that who we've said are the heirs are in fact the heirs. So there's the addition of a fee that's going to be charged by this attorney ad litem. Further, there's the need to have all of the beneficiaries agree on a independent administration. If you have a minor child or someone who's incapacitated, they can't agree to that. And so now we're being forced into a dependent administration, which is going to take a lot more time and a lot more cost in the long run. But the difference between being able to probate a will and having go through an intestacy process is not only several months in time trying to get the matter set before the court, but also several $1,000s. And really, just a simple will could have avoided all of that.
Okay, so we've talked about beneficiary designations. Let's say I start a new job. I fill out my life insurance form. I fill out my beneficiary designation on my retirement accounts. I am good, right? In other words, I don't have to worry about this anymore. My family, my kids, my loved ones are protected, right?
Hopefully, but I always say it's really, really important to just think about these documents. Not every month, not every week, maybe annually, let's say, some point in time, something triggers it. But more importantly, when there is some life event, the birth of a child, the death of a loved one, it's always really a good opportunity to go back and see who you have named, because it's important that those documents also be updated as your personal circumstances change. So as I'm meeting with clients, even though they tell me they've got those forms and they've identified the persons that they want, I always sort of leave them with a little homework saying, please go back and double check, because oftentimes what you think you may have done 10 years ago is not in fact what you did do.
And what happens if I don't update those beneficiary designation forms?
Then, as we said, the unintended consequences, those horror stories can happen. Situations where the wrong person receives the money, or situations where the money passes to the estate because the beneficiary has died, has predeceased you. So issues such as that can come up, but issues like that can easily be avoided.
So it seems like the moral of the story is to make sure that you pay attention, you fill out the beneficiary designation forms in the way that you intend, and to go back from time to time, if there's some new life event that happens, to go back and review those and make sure that they still comply with what your intent is.
It's exactly right. It's as simple as that.
Thanks so much, everyone, for joining. Make sure to hit that like button and subscribe to the podcast to make sure that you stay on top of the latest for estate planning, probate, trust, and guardianships. We have lots of really exciting episodes coming up. Thank you all for your support, and make sure to like and subscribe. We'll see you on the next one.